Welcome back, and let's welcome attorney at law, Mr. Martin George. Good morning and welcome. Happy New Year. First time I see you for the year, man.
Yes, hi, good morning to you, brother. No, we spoke already for the year.
We did? Okay, all right. Well, you see, I can't.
Yes, we did.
All right, let's go. Yes, let's go to this contentious issue. Obviously, the public is feeling it. 9 men have to be awarded $20 million for malicious prosecution, Mr. George. Give us your overview.
All right, well, brother B, I mean, the fact of the matter is that these are the types of cases that one would normally expect that the state would defend and defend vigorously. Because when you consider it, to start off, this was a very high-profile murder, all right? And this case took all kinds of twists and turns. If you recall, even Miss Naipaul Kuhlman's husband was under investigation because there was an allegation that he had paid some money as some sort of a bribe or, you know, something of the sort in the early stages of the matter. That was investigated. Then you had the 9 men charged and they were brought to court in this matter. Prosecuting the case, you had 3 senior counsels. You had Dana Sitahal, you had Israel Khan, you had Gilbert Peterson. So 3 senior counsels the state paid to prosecute this matter. So you're talking several millions there again that would have gone in the prosecution of that matter. The matter went on appeal at some point, so you're talking more money that the state spent. It came back down again before Justice Holdup, Malcolm Holdup as he then was, right? Eventually, the 9 men were freed. So this is the type of situation where you would have imagined, even before going to court, even before you charge these men, the police would have gathered their evidence. They would have taken their statements from witnesses. They would have put everything together. And they would have gone and consulted with the director of public prosecutions, another senior counsel, you know. So the fact of the matter is that you ask yourself, is it that the police didn't know what they were doing when they were charging these people? The director of public prosecutions, when he gave instructions to say, go ahead, lay the charges, and then furthermore, to go and retain 3 senior counsels at millions of dollars to prosecute the matter. It cannot be that you are suggesting that, look, the state didn't know what it was doing, or that it had no basis or no evidence whatsoever. Otherwise, I mean, our whole system makes absolutely no sense. So therefore, if they had all of this information, the more troubling question is, okay, so all right, they're freed by a jury, that's the process we have. But when they come now to file malicious prosecution, all the evidence you had prior to laying the charge, all the evidence you led in court, these are the things that you would now present in this defense in a civil claim to say, listen, we did not do this maliciously or without reasonable or probable cause. We had more than good reason. We had more than sufficient evidence to be able to justify doing this. So therefore, this is what we had. This is what the statements we had. This is the evidence we had. This is the DNA evidence. This is the blood sample. This is whatever. So this is what you would now put forth in your defense as the state, as the Attorney General's office, to say, listen, this malicious prosecution claim has no basis. In fact, at the Attorney General's press conference a couple of days ago, you heard him say that the state had so much evidence for their defense that it would have been a slam dunk defense. Those were his words. So in other words, he's speaking so confidently and cockily now to say, well, look, they would basically have stood no chance at all if the state had put in its defense. So then, Brother B, the $20 million question is, why didn't the state put in a defense?
Okay. That is exactly the question I was about.
That is the $20 million question.
Well, hopefully we can find some answers. But also the Attorney General also said that the he spoke about the disappearance of the file, and he also said that this was a sinister development. Is that statement holding any water?
Well, I mean, the point is, I mean, one always has to have due deference and respect to persons who hold high office. And if the Attorney General comes out and says that, then that's not something you can dismiss, you know, ab initio. You must give some deference to the fact that, I mean, he's saying so. However, it doesn't stop you from asking questions. And some of the questions you would ask would be, okay, so if the file disappeared, how is it the state was able to file an appearance in the matter? What did you use to file the appearance? If you understand me, you know, so you have a lot of troubling questions occurring. You also would be able to ask questions, all right, so when these persons filed their application to take up judgment, because remember, there's an application that has to be filed before Justice Joan Charles, who eventually granted the order, that application is normally served on the state. So even if you claim you didn't have a file, when that application would have been served on you, then at least you would have been reminded about the matter. You would have then made inquiries. And let me tell you, Brother B, it's a normal thing even among attorneys. If, for instance, you don't have your documents at hand, you could even call the attorneys on the other side and say, listen, send me a copy of the documents. I need to be able to prepare myself. Or you apply to the court, just as they did recently, because you heard it said that, you know, Mr. Stuart Young, when he was there briefly last few days, he applied to the court and got a copy of the entire file. So it's possible, and that happens all the time. You could do that. In addition to which, Brother B, we are now in the era of electronic filing and electronic service. So nobody has to necessarily rely on a physical file being present, because they serve documents electronically, they are filed electronically. So you just check your computer for the documents, right? Ever since the pandemic, we have moved to that electronic filing platform, and that has remained in place. So you see, the questions that arise based upon the statement from the Attorney General are more intense and searching and searing rather than the explanation that he has given. And it therefore now brings into question the explanation that he gave. And it gets worse than that, Brother B, because you had two attorneys from the state, from the Attorney General, representing the Attorney General at the assessment of damages. One of those attorneys is actually now a High Court judge. So, I mean, it puts all of these things into question. Where would they have gotten instructions from to go and appear on behalf of the Attorney General if, according to the Attorney General, they only now saw the file 2 days ago? That makes absolutely no sense, with the greatest of respect.
Right. Staying with disappearing evidence, if you want to call it that. One of the highest profile cases, Dana Sita also disappeared, along with the body of Ms. Coleman disappeared. What does that tell you? This matter had to become. What happened in that instance when these elements of prosecution disappeared?
Yes, well, I mean, Dana Sitahal, I mean, she was murdered, and I mean, of course, you have persons who have been charged for it, as to what was their motivation, or, you know, who motivated them. I'm not sure that has come out yet in the public domain. Of course, you have lots of persons who have raised speculation in the public domain, but I mean, of course, we don't get into that. We deal with the facts that are before us, you know? So the thing is, coming back to this malicious prosecution issue, you also had another very interesting scenario that I wanted, you know, just let you two gentlemen be able to share with your listening and your viewing public. The state attorneys who represented the Attorney General's office in the assessment of damages, they actually made a counter offer in the matter. all right, because Mr. Logan and his team, they were asking for $3.5 million in damages for each of the prisoners. The Attorney General, through the attorneys who represented him, they offered $1.2 million each as a counter offer. Where did those instructions come from? In
Okay.
other words, if the Attorney General is the defendant and your attorneys are there in court making this counter offer, are you saying that they did that on their own without consulting you, the Attorney General, without getting those instructions from you? Nothing about the explanation makes any sense, with the greatest of respect, when you ask these hard questions. And, you know, I mean, we are not doing this to embarrass anybody or embarrass any particular office or anything of the sort. We are simply asking the questions which follow from common sense. And we must always remember, Brother B, the 1936 Privy Council case of Ambad versus Attorney General. It's actually a case from Trinidad and Tobago, right, where the Privy Council in 1936, Lord Atkin said, justice must not be a cloistered virtue. She must be made to suffer the searching, though respectful, inquiry and comments and criticisms from ordinary men. Because, in other words, what he's saying is that, look, don't think that you could isolate yourself in an ivory tower and think, well, okay, because you are clothed with this office or this authority, that you are beyond scrutiny. No. So if you've given an explanation and you said the file disappeared, then people are entitled to ask these questions. Okay, if the file disappeared, how did you enter an appearance? How did your attorneys be appearing for you in the matter if nobody had a file? It just begs all these questions, and the explanations and answers are still hanging and waiting in the balance as to how you are going to, you know, get around this quagmire in which you appear to have found yourself.
Mr. George, how does the state, or how should the state proceed on a possible appeal of the default judgment handed down this week? How, in your view?
No, the default judgment was given quite some time ago by Justice Joan Charles. What we have now is the judgment and the assessment of damages for the sum of, you know, almost $20 million.
Yes.
So the default judgment, that was given a long time ago, and that's what I'm saying. Even for that, the normal practice is you serve the other side. So in other words, the state ought to have had notice when that application was made for the default judgment. So why didn't you go and defend it then? Why didn't you say something? And another thing going to be, even the attorneys who were representing the state at the assessment of damages, I have a copy of the judgment. And looking at the judgment, nowhere in there do you see anybody from the state or from the Attorney General's side complaining and saying, well, we can't proceed because we don't have a file, or that judgment in default should not have been entered. No, you had two attorneys who participated. They asked questions, they cross-examined people, they made legal submissions, they made an offer of settlement of $1.2 million. So you did all of this and you had no file? What were you referring to? Where were you getting your instructions from? Where did you have your information if you did all of this without a file? And what makes it worse is that you heard an attempt at a disaggregation, of the Solicitor General's office and the Attorney General's office. No. If you go on the website, and I urge your listeners and viewers to do so, go on the website for the Ministry of Attorney General and Legal Affairs. And you will see under one umbrella, all of these offices are there. All of these offices are there under one umbrella. In fact, they even have a slogan, right? They said all our departments in one place serving you, if you understand me. So therefore, you cannot now come to try and suggest, well, the Attorney General's office didn't know what the Solicitor General's office was doing, or the Solicitor General's office didn't know. No, you cannot. It's one umbrella organization, and they actually say so on their website when you go and look at it. So therefore, it really raises more questions than answers, and I think that we ought to call upon the authorities to give us some proper answers, because this is a most egregious and, upsetting state of affairs. I think every citizen, every right-thinking citizen must be outraged by this in those circumstances in which it occurred.
And what if, Mr. George, that these gentlemen are are to be legitimately rewarded in that they have no evidence to prosecute them and they are indeed innocent? For example, and there are cases that are going to come up where people are maliciously prosecuted because some officer didn't like them. In that instance, those individuals have the right to redress, and thereby, and a brilliant lawyer would advise them to sue the state. Now, and clearly, these gentlemen obviously were properly advised, but the challenge, as you mentioned, why wasn't an appeal, I don't want to say appeal, but why wasn't issue raised? A defense raised.
Yes.
Bring that into perspective of what I just said as well.
Right, okay. So, and this is where, it harkens back to the investigation and the prosecution of the matter. This, as I said, could not go forward without the DPP himself having reviewed the file. He would have sat with his attorneys in his office, looked at the evidence that the police brought, looked at the statements, looked at the evidence from the witnesses, whatever evidence from DNA samples, whatever they had. They would have taken a decision. Yes, we have enough evidence to be able to prosecute this matter successfully. Because it's not just to prosecute, you want to prosecute it successfully. They would have then taken the decision, we have such a good case, we are going to hire 3 senior counsels to prosecute it. Not 1, not 2, 3, at the cost of millions of taxpayers' dollars. So when you add up the total cost, Brother B, of this entire Vidya-Naipaul Kuhlman matter, it is probably, maybe it might run to hundreds of millions in terms of what it has actually cost the state. Because when you consider the fees for those 3 senior counsels there, and then the matter went on appeal, so the fees at the Court of Appeal, and then now I see they are appointing retired justice from the Caribbean Court of Justice, Justice Ralston Nelson. The Attorney General has now appointed him to lead the investigation into what happened. So, of course, you're talking more fees, maybe more millions again. So, in other words, you have millions and millions and millions of taxpayers' money being wasted, it would seem, in a prosecution that went nowhere, a claim that was undefended by the state, and the explanations and answers just don't add up any which way you cut it, slice it, or dice it.
All right, Mr. George, we got to leave it there this morning, and we want to thank you. Always very informative, and indeed a pleasure to have you.
Yes, man.
Always. Thank you very much. Have a great morning.
Yeah, we're going to leave it there this morning with Mr. George, and of course, at this point in time, we go for a break. When we come back, we talk Calypso, all you. See you after the break.